Good morning, good afternoon, good evening, according from where you are watching us. It's a pleasure on behalf of the International Association of Youth and Family Judges and Magistrates to be with you today on this webinar. My name is Eduardo Melo. I'm judge in Brazil. I'm also the editor-in-chief of our journal, The Chronicle, and I organize these webinars. Today, we are going to discuss trends in new legislation on judicial reform in child matters, and we are going to focus the example of Italy. We believe in our association that it's very important for all judges and magistrates to know and understand the challenges that those reforms may bring to specific countries and what they may represent for the justice system all over the world. So the example of Italy is a nice starting point for this discussion in our association. We'll have the opportunity to listen to our main speaker, Judge Daniela Bacchetta, who is a judge, juvenile in the Juvenile Court of Rome. She's also a member of the International Hague Network of Judges, and from 2007 until 2013, she was director of the Italian Central Authority for the Hague Convention of 1993 on intercountry adoption. From 2014 to 2016, she was director of the Italian Central Authority for the Hague Convention of 1980 on international child abduction and the Hague Convention of 2007 on international recovery of maintenance. So she's a person who is deeply connected with all trends in the justice system. It will be a pleasure and an honor to have her with us. And after that, we'll have a debate with questions raised and comments raised by Joseph Moyersoen, who is an honorary judge in Italy, and our former presidents. So I have had the opportunity to work with Joseph. It's always a pleasure to be with my dearest friends. And also Dr. Ursina Weidkuhn, who is a former Swiss prosecutor and judge and international consultant and member of the board in this mandate. So we'll begin with Judge Daniela Bacchetta. You have the floor, and thank you to be with us today.
So thank you very much, Eduardo, for having me, and hello to everybody, wherever you are. So let me first of all express my gratitude, my personal and the one of the Italian Association of Youth and Family Judges, for this opportunity to talk about the forthcoming reform here in Italy regarding jurisdiction and procedures in child and family matters. But I needed to begin with a short description of the current situation in Italy as it is since many years now. This is necessary to understand what is coming soon. So far here in Italy, procedures regarding family and children issues are split between ordinary courts and juvenile courts. Ordinary courts are competent for separation, divorce, and related claims on custody and maintenance of children born in the wedlock, as well as for custody maintenance of children born out of the wedlock. On the other hand, juvenile courts are competent, of course, for criminal proceedings regarding crimes committed by juveniles, but in the civil matters, they are competent for any issue regarding child protection with an impact on parental authority, limitation and withdrawal of parental authority, replacement of the child outside the family, declaration of adoptability, adoption, both simple and full, and also eligibility for adoption. Quite a wide palette of competencies. At each juvenile court, there is the office of the juvenile public prosecutor. And in civil cases, it is competent for promoting civil procedures for child protection after receiving reports from local services or police. In particular, it has an exclusive competence for promoting adoption procedures. And the juvenile public prosecutor is also present during the civil procedures because it has to express its opinion before the final decision of the court. Now let's look at the difference between ordinary courts and juvenile courts regarding their territorial jurisdiction, because all this is important in regards to the forthcoming reform. At present, we have in Italy 163 ordinary courts spread all over Italy and 29 juvenile courts. Each juvenile court has the same territorial competence of the corresponding Court of Appeal. It means that the juvenile court's territorial jurisdiction covers more ordinary courts, usually from 3 little juvenile courts to 10. For example, in Tuscany, there is 1 juvenile court in Florence, seat of the Court of Appeal, and 9 ordinary courts, 1 in Florence and the other 8 all over the territory. The same in Lazio, in Lombardy, in many places all over Italy. There are differences in procedures. Juvenile courts apply in most cases a simplified procedure leading to decrees. Ordinary courts apply in most cases a much more complex procedure leading to sentences. We have differences, and it's very important, differences in composition. An ordinary court so far works and decides in the composition of 3 professional judges. In the juvenile courts, decisions are adopted since now by 4 judges, 2 professionals and 2 experts, honorary judges. And this, as I said, is the big issue in which we are going to face a big change due to the forthcoming reform. Just words to remember the history of juvenile courts, which were instituted by a law in 1934. It was a law adopted during the fascist period. It had a very important social and political sense, but notwithstanding, it proved itself to be a modern and somehow visionary law capable to adapt to times and changes of society. In particular, it was revolutionary by creating a judicial body composed not only by professional judges, but also by experts in psychology, psychiatry, anthropology, criminology, social sciences, and similar. And these experts, the important thing is that they were meant to be not mere consultants of the professional judges, but members of the court, of the panel, on an equal level as the professional judges. Since then, this composition has allowed a multidisciplinary approach to cases falling into the competence of the juvenile courts. Honorary judges with their different specialization and professional experiences facilitate comprehension and liaising between the court and the local service, between the court and the society, can better evaluate measures of protection, have a specialized approach with children and adults, help, and this I cannot stop emphasizing, help to predict the results of the decisions and development of the situation, which is vital when children are concerned. And honorary judges proved this way to be essential to a child-friendly justice. That said, the presence in Italy of 2 different types of courts, ordinary courts and juvenile courts, with different competencies regarding family and child protection issues, could and did lead to some cases to overlap the actions with eventually contradictory decision. Since years now, the necessity of a court unique and closer to users has been claimed by also by us juvenile judges. The Italian Association of Juvenile Judges itself, as I said, is convinced of it, and some years ago proposed a law draft suggesting how to realize a new family court in which all competence regarding family and child protection could converge and meet and be dealt with by a specialized judge, so preserving the multidisciplinarity composition of the current juvenile court. The crucial problem was and still is coping the specialized composition of the court with a number of courts in which family and children issues are dealt with. In other words, how can the specialized composition be assured in 163 courts spread all over Italy, which are the proximity judge, much more than juvenile court? I said that we have 29 only in all the territory of Italy. Besides this problem, which was thoroughly discussed long years, another must be mentioned, and this is a problem. That is, a mumbling of diffidence began to spread in the last years around the presence and role of honorary judges. Fear that a competence different from a strictly legal competence can harm the rights of defense when the 4 judges convene and deliberate in closed session. Sort of annoyance that hearings, the hearing is dealt with by the honorary judge instead of by the professional judge, with a potential lack of accuracy that could influence the outcome. Of course, you can understand by my words that this was a problem mostly by lawyers. We have some lawyer associations that have grown over the years more and more aggressive in this stream. Let's add that sometimes media have emphasized cases where children have been removed from their homes that become real campaign against the juvenile courts. I've summed up, described some problems we have gathered during the year. And so the actual general opinion in favor of a unified court, the difficulty in finding a solution in order to maintain the specialized composition if the competent courts are spread all over the territory, the drift of diffidence against the honorary judges and juvenile courts. These problematic issues are the field where in year 2020, Next Generation EU lands. I mean, in relation to Next Generation EU, Italy, as other countries, committed itself to launch a package of reforms aimed to make stronger and more efficient the public administration and the productive system. Among these reforms, there are the ones aimed to make justice more efficient and quick, both civil and penal. In this sense, the watchword has been make it quick, make it simple, and it was the order. The technical instrument used in Italy in order to realize these reforms is the legislative decree, Decreto Legislativo, which means a 2-step procedure. First, a law approved by the parliament set forth a batch of detailed criteria and delegates the government to develop these criteria. Second, the government produces a bill strictly following those criteria. After some passages and approvals, the legislative decree is published on the official gazette and has the same value as a law approved by the parliament. In our case, in May 2021, a commission was established at the Ministry of Justice, composed by several experts, none of them being a juvenile judge. It was a commission charged of and drew up a report that examined thoroughly the civil procedure, all the civil procedure, including procedures to be applied also by juvenile courts. That's why the presence of a juvenile judge, experts in juvenile, in law of children, the juvenile courts, should be important, but there was no space. This commission released a first version of a report containing a detailed complex of innovating criteria to be followed by the government, and also some new rules that should come into force at once. not by the draft, but with the delegated decree. Among the innovating criteria to be respected in the following drafting of the reform, there is the prohibition that honorary judges at the juvenile courts hear the child, that being reserved to the professional judge. And this is quite eloquent on the mood of the reform. Among the proposed rules to be applied at once, 3 regard family law and juvenile courts specifically. Among them, a new rule aimed to distribute competence between ordinary courts and juvenile courts that favors ordinary courts. And again, this is a sign of the mood. Second innovation regards the procedures to be followed by juvenile courts after a child is urgently placed out of the family by social services in order to confirm, modify, or revoke the order. And we could appreciate that this new rule was very strict and very binding, tailored on the example of arrest, which is not a good alignment. The Italian Association of Juvenile Judges expressed, of course, concerns and proposed changes not taken into account other than marginally. I must say that the party of lawyers, it's very strong in Parliament where it counts. The first version of the bill draft envisaged also the institution of a new court, the Court for Persons, Children and Families, meant to take the place of juvenile courts and ordinary courts in the field of family law. In this first version of the bill draft, it was only a short passage, speaking of it, with no articulated proposal. So the association was driven to think that that was a second stage, something to discuss on, where the discussion could be open. Only at the end of July 2021, a new version was released, or a new version of the draft was released, actually known a little later, where this new court of persons, children, and families would take a meticulous shape. And again, no juvenile judge nor the association, as I said, were asked to give suggestions and express opinions. According to this draft, the new court for persons, children, and families should be autonomous, which is good things, not secondary, accessory to the ordinary court. It's an autonomous court and articulated into sezioni circondariali, local sections corresponding to ordinary courts, sezioni distrettuali, central sections corresponding to the current juvenile courts. Local sections, according to the draft, are charged with any and all civil cases regarding persons, children, and families, separation, divorce, custody, protection orders of the adults and children, removal of children from the family home, placement in shelter homes, foster care, limitation and withdrawal of parental authority, and so on. Decisions are adopted in this local section by the single judge, no more by a panel of judges, let alone by a panel composed also by honorary judges. That has been the big stroke come out of the blue. Central section, sezioni distrettuali, will maintain the competence on proceedings regarding crimes committed by minors of age, and as regards civil cases, central sections will be competent on appeals against the decision by the sezioni circondariali local sections and on adoptability and adoption procedures. Central sections will maintain the current composition, 2 professional judges and 2 experts, only for criminal cases, adoptability and adoption procedures. When deciding on appeals against decisions made by the local sections, the central section will be composed only by 3 professional judges. All this means that in almost all civil proceedings regarding family and child protection, honorary judges will play no more role, no matter how difficult and delicate the situation are. Or better, according to the draft, part of the honorary judges of the current juvenile courts could be moved to the local sections of the new courts. We'll see if they agree. And will make part of the so-called ufficio del processo, which means the judges' supporting staff. As a general rule, the ufficio del processo is already existing at every ordinary court, and it is meant to help the judge by carrying out any activity preliminary to the jurisdictional function. That is, for example, checking and tying up files, collecting documents, checking services, researching precedents. The Ufficio del Processo is already existing at the ordinary courts, is composed by chancery offices, trainees, people graduated in law, and the honorary judges. But these, at the ordinary courts, are people graduated in law, actually very keen, very near to the competence of the judge. They are not experts in the meaning of the current juvenile courts. These honorary judges at the ordinary courts can also be appointed by the professional judge to take care and even decide single cases, but only when they are simple. These rules are moved and applied also to the new court for families, persons and children. It provides that the honorary judge, the ones moved from the current juvenile court to the local section, so the other kind of honorary judges, will perform the above said preliminary activity, but also perform conciliation, inform parties on family mediation, help the judge in hearing the child. But as I said before, the draft provides that the hearing of the child cannot be delegated. It must be done by the professional judge, eventually decided by the honorary judge. The professional judge can assign to the honorary judge strictly specified activities. It is absolutely clear in our view that the scope of all this is to relegate the honorary judge to minor activities, to reduce the danger, as I said before, of impacting the decision of the professional judges. As soon as this draft circulated, the Italian Association of Juvenile Judges expressed vigorously its concerns on the loss of multidisciplinarity and collegiality and proposed some changes. It had to limit itself because it was clear that there was a little, if no, but okay, suggestions were made. In particular, the association suggested to keep within the competence of the sezioni distrettuali, central sections, cases regarding withdrawal of parental authority, which are usually the most sensitive, in order to be dealt there with and decided by the panel, including honorary judges. In October 2021, Cristina Maggia, the president of our association, was heard by the Justice Committee of the Chamber of Deputies and passionately exposed our views, concerns, and proposals. More, a meeting of all juvenile courts presidents and all juvenile chief prosecutors with the Ministry of Justice was held on October 20th, 2021. In that occasion, it was by the judges and the public prosecutors made abundantly clear and explained that most civil cases regarding child protection are far from simple, even if not dealt with in an adoption procedure. An adoption procedure, despite of the name, can be quite simple. We can think of the adoption by the husband of the mother. This is an adoption, but it's not complicated. That cases, it was explained that cases regarding child protection are never recurrent and each needs an in-depth examination. It was clear that most adoption procedures are a development of a previous civil cases where parents proved to be severely inadequate. That the contribution of honorary judges cannot be simply overcome and replaced by appointing private experts in order to produce technical reports. That in any case, there is no hope to make the reform succeed without a massive increase of judges, public prosecutors, and material resources. By the way, the draft specifically provides for no new costs. At the end of that meeting in October 2021, it seemed that a doubt was sowed. The ministry herself promised that some adjustment would be made, but so far nothing changed. In the meantime, also the Supreme Council of Judiciary and the Italian Association of Judges expressed themselves approving, as we do, the creation of one court competent for all matters regarding children and families, but pointing out the critical issues, as we did, in particular, the abolition of multidisciplinarity and collegiality, and the absence of any provision of the necessary increase in staff and resources. They stressed the predictable increased use of private experts to be paid by parties and with public money as a consequence of the exclusion of the honorary judges. That is, the cost of jurisdiction will rise. But as I said before, the watchword was quick and simple, and therefore a law number 206 passed in last November, detailing the principles the government had to stick to in the reform of civil procedure, including the abolition of juvenile court and the creation of this new court. No change was made to the draft, even on the lack of financial resources. Afterwards, the Ministry of Justice appointed a committee composed by experts, and this time there was some juvenile judges involved, but I mean, it was late. Criteria cannot be discussed, cannot be changed. So it was a very strict path. This committee has been charged to elaborate the text of the Decreto Legislativo, and the final text elaborated by the committee has been transmitted to all bodies, organs for approvals, and finally sent to the Council of Ministers. I can add here that in the last months, the association's position was strengthened, we thought it was strengthened by the resolution of the European Parliament approved in April 2022 that recommends that the member states adopt a multidisciplinary approach in proceedings on the protection of children. But once again, it had no echo. Some weeks ago, it has been announced that the Council of Ministers has approved the draft. The next step will be the publication on the Gazette, on the official Gazette, and it will enter into force apparently on June 30th, 2023. So, if nothing happens in the meantime, juvenile jurisdiction in Italy will dramatically change. We'll have an only and alone judge who will face the widest palette of child protection measures. Almost all decisions, even the ones that change the lives of people, will be adopted by a judge, always alone. To us, it seems that this is a reactionary reform, where procedures articulated have in mind the conflict between adults and not the protection of children. And this will inevitably lead to not see cases where local services are not strong, not pugnacious, not able to force the doors. Of course, the Italian Association of Juvenile Judges will go on fighting and promoting the multidisciplinarity and collegiality in view of the best interests of a child. Time will tell, we'll see. But thank you for your attention.
Sorry. Thank you very much for your very clear presentation, Judge Daniela Bacchetta. I think we all have a lot of questions and concerns about this reform. That, in fact, it has a lot of connections with all the discussions that are being held in different countries. So it's with pleasure that we are going to hear now Judge Joseph Moyersoen, and afterwards we'll give the floor to Dr. Ursina Weidkuhn, and then we will begin our discussions. I invite the people who is watching us on YouTube. If you have any questions, you can write them, and I'll share with our speakers. Joseph, you have the floor.
Thank you, Eduardo. Good morning, good afternoon, and good evening to everybody. It's a pleasure also to me, for me to be here. And I heard with very attention the interesting presentation of Daniela Bacchetta, and very clear, and you could understand, I think, the most worst problems that this reform can be faced with in the implementation. To understand better the Italian juvenile justice compared to that of other European countries, I think that I can give you some indicators. The first indicator is to be taken into consideration with respect to the functioning of a juvenile justice system is that provided by the statistical data. There are not many comparative studies on this topic. However, according to the data released by a transnational research over 15 years ago, Italy was the country that had the lowest rate of juvenile delinquency compared to both other European countries and USA, United States of America, as compared to 9.7 children with a criminal case open per year by 1,000 children having the age of criminal responsibility in Italy. There were 24 in Greece, 33 in England and Wales, just over 43 in France and Finland, and 82 in Germany. And this can give also an important element. The second indicator to be taken into consideration is how international organizations assess the Italian juvenile justice system. Daniela already explained what the European Parliament said. And with respect to binding and not binding international legislation, soft law. In this regard, it is useful to recall the concluding observations of the United Nations Committee on the Rights of the Child on the administration of juvenile justice system, in which it praised the system in force in Italy and harshly criticized the attempts at previous reforms already made or not entering into force, of course, because they jeopardized the good functioning of the system. The first indicator is the position taken by the juvenile judges in the present reform, and Daniela already explained very well the strong work that the Italian Association made during last 1 year and a half around. And is interesting, in fact, it is in fact evident that the expected radical marginalization from the hearings of honorary judges, especially of children, thanks to which most of the most overburdened juvenile courts are able to guarantee a qualitatively and quantitatively adequate functioning, will lead to the impossibility of guaranteeing prompt interventions in mainly emergency situations and serious delays of the handling of the civil procedures. in light of the current very modest organic plans of the juvenile judicial offices that will not be implemented and that need to be clear. As Daniela said, who has a long experience as a juvenile judge pointed out, one of the most worrying aspects is the strong downsizing of the role of honorary judges, those competent professionals of human sciences, medicine, sociology, and more, which support the professional judges and help to humanize the treatment reserved to children and young people. According to this approach, legal knowledge is integrated with other knowledge relating to social sciences, humanities, and medicine. In the law of 1934, then quite 100 years ago, which gave birth to the juvenile courts in Italy and which configured the role of honorary judge, there is talk of meritorious of the social assistance, meritevoli di assistenza sociale, which contains a background concept, which then naturally it must be supplemented by other skills. In fact, the decisions up to now have always and all been taken by a panel, precisely by examining at 330 degrees all the elements that make up the life of a child for the purposes of making decisions in civil, criminal, and adoption matters. With the reform, honorary judges remain, but with many limitations, as already Daniela said, only at the district level in criminal and adoptions matters. Practically in the current 2009 juvenile courts, while they will be completely absent in the peripheral level in the 165 ordinary courts, to which the reform assigns the greatest number of competencies in civil matters. Have a single and non-specialized judge would find himself having to make important and very delicate decisions on his own, such as the replacement of a child from the family or limitations of parental responsibility. It is certain, however, that the single judge whom the reform assigns a priority role cannot count on his colleagues, honorary judges. He will have to rely only on technical expertise on whose content, not being specialized, he can hardly object. And all this judge, as Europe confirms to us, that the judgment of a child must be formulated by a competent panel, as Daniela said. And at last, let me say that the reform of the judicial system without investment of resources at no cost, at zero cost, is worth value. It is equal to zero. The last indicator is provided by an examination of the situation of other European countries which have experienced the reform in the juvenile justice system since the beginning of the present century. I just give you a free example. Austria, and maybe somebody from Austria still listen and can say something about it. In Austria, the Jugendgerichtshof, juvenile court, existing until the early 2000s, has a specialized court very similar to the Italian one, with a dual jurisdiction, civil and criminal matters, with the presence of honorary judges in the decision-making phase of the various proceedings, with joint training and so on. The legislator adopted a reform in 2003, which transferred all the civil jurisdiction of the Jugendgerichtshof to the ordinary court, already competent for separations and divorces. However, given to the negative results of the reform, it was subsequently debated, especially by the judges, the juvenile judges, and also the ordinary judges, whether it was preferable to reconstitute the specialized court that existed until 2003. In Belgium, With the law of July 30, 2013, the Belgian Parliament adopted a reform that established the Tribunal de la Famille et de la Jeunesse, Family and Juvenile Court. The reform came into effect on September 1st, 2014. And so the unification of many competencies scattered among different courts, the Tribunal de Première Instance, Court of First Instance, the Juge de Paix, Judge of the Peace, and the Tribunal de la Jeunesse, Juvenile Court. In practice, the Family and Juvenile Court, with specialized personnel and exclusive jurisdiction, is located in the Court of First Instance and is composed by 3 different chambres, sections. The Chambre de la Famille, with jurisdiction in the civil matters, including divorce, parental responsibility, filiation, and adoption. The Chambre de la Jeunesse, with civil and criminal jurisdiction in example matter of child protection and of juvenile offenders. The Chambre de règlement à l'amiable in the matter of alternative solutions to family conflicts. However, still outside of this new court, all the custodial matter, guardianship, and so on. I know from our Belgian colleague that the reforms still have many problems in the implementation, and we are around 8 years of the implementation experienced. And finally, Hungary. In 2011, but I have very few information on it. I couldn't reach a lot of information on this reform. In 2011, Hungary adopted a reform that changed the composition of the juvenile court in juvenile criminal matters. Along the lines of our preliminary hearing in criminal matters in Italy, with respect to the composition, 1 professional judge and 2 honorary judges. I conclude very quickly, in the legal reforms, such as the one on the way in Italy, one of the important aspects is the essential provision of human and economic resources to allow the system as introduced or modified to be able to operate first of all in full compliance with the principles established by international standards, primarily those contained in the CRC. Thank you very much.
Ursina, please, you have the floor. Thank you very much, Joseph, for your contribution. It was very interesting to see this panel of what is happening in other countries in Europe. We have with us also Renate Winter, who was our former president, and after Ursina make some short comments, and then if Renate allows us, I'll give her also the floor to make some short comments on this reform in Austria, because I think it has some, as Joseph has mentioned, there are some similarities, and it would be very important for us to have some inputs on what is going on in your country. Ursina, please, you have the floor.
Yes, thank you so much. Thank you to Daniela, to Joseph, and also Renate for joining. From my side, not too much. I have a lot of questions, but that maybe will be asked by others later. A very short, a few reflections only from a comparative perspective. First of all, I think it's a very valid of the Italian juvenile judges to really focus on the element of multidisciplinarity, of the importance of that element for a child-friendly justice system. This is very clearly stated in the European, all the regional guidelines on child-friendly justice, and it's clearly in the spirit also of the international standards, including the Convention on the Rights of the Child. There's no doubt about that. So when I look at how to, let me maybe talk quickly about Switzerland. There we have basically separation, just to have another example on the table, between civil law and criminal law. And child protection is a bit of an overlap system. We do provide child protection partially by the criminal law system and partially by a separate a separate leg from the civil law, administrative law side. For instance, me as a juvenile prosecutor judge, if a child is in conflict with the law but needs protection, urgent protection, maybe needs to be taken away from the family, the juvenile judge could order such a placement of the child in a different environment, despite being basically a juvenile judge in the criminal field. And here also we would do that indeed as a single judge. So this is then not a group of people, this is not a team, it would be a temporary decision taken by a juvenile judge. There is some backup, so we are not fully non-multidisciplinary. Our backup here would be this person, this juvenile prosecutor judge is quite a specialized personality or professional, has a social work service in his office, her office, which would of course be consulted and to give advice. And as you mentioned, one can get some external expert opinions. And they said it would be a temporary decision, which would be reviewed later by a team. So I'm not saying that this is the best approach of all. I just say in certain moments, it might be a workable approach as well. We found it is okay so far, but looking at, often we just, what we know, we find is fine because we know it, and it has never been differently. That doesn't mean that it is best. That is why we do exchange here. Now, the same situation of the same child who had not committed a crime would be dealt with an interdisciplinary administrative or court team, multidisciplinary, as you were mentioning. And there, I think we have good, we are happy with that as well. And we definitely appreciate the system of having these multidisciplinary teams making these decisions in that field. I just wanted to mention that, yeah, quite often we say various ways lead to Rome, as we say. Certainly important is to always think about what is the key criteria, indeed, that somehow this multidisciplinary knowledge is there and is used in the best interests of the child, which is coming along with a high demand on a very good qualification, specialization for all professionals involved. There I see troubles if you have so many different tasks, how to keep people, the decision maker, highly professional in all fields. And then, of course, the element of a good coordination, of good implementation structures, of sufficient resources. This is maybe a bit of key elements which we need in all reforms, and we have to look what fits in the current embedment. We can compare, but then we always have to go back to our own embedment, what is around in our system. So now with this, maybe I hand over to Renate so that you can see also and then bring in this comparative perspective from your country, which Joseph brought up before.
Hello, can you hear me? I do not know if my thing works. I never know. Okay, thank you very much. Thank you for welcoming me as well. And thanks especially to Ursina, because Eduardo, you did send me a YouTube, but not a Zoom. And I don't have YouTube. So I was kind of helpless. And then Ursina helped me out. Thanks a lot. Concerning the Austrian system, we have since the very beginning, we also had a unique judge who started with dealing with a child completely, so to say, civil matters, penal matters, protection matters, and so on. Then we had a decision of the Supreme Court and the Constitutional Court, and if I remember correctly, but I am not sure, also from Strasbourg, that it is not correct to have one judge who is dealing with a child in civil and penal matters, the same judge with the same child, because the same judge could then be biased when it comes to penal matters. From that moment on, we had a complete separation between civil and penal matters. We have the Jugendgerichtshof, the juvenile court for penal matters only. So the juvenile judge in the court is dealing with children in conflict with the law, not anymore in contempt with contact with the law. So victims and witnesses are dealt with only when they are victims and witnesses in penal matters. Everything concerning the protection also of victims and witnesses is always dealt by the family court. It's not an ordinary civil court, it's a specialized civil court, namely the family court. The family court has specially trained judges with all the matters concerning families, from divorce to adoption to child protection, everything. And the penal court has only penal matters. But both courts have the assistance and the very strong assistance of the administration by social services. The civil courts have specialized civil social servants who know exactly about how to deal with families, with child protection, with how to get a dialogue with the family and so on. And they are the first instance. So if a child has problems, it addresses the administration, namely the child institution, the institutions that are dealing with child protection. Only if those social workers and the family cannot cope, cannot agree on something, then the civil servants or the parents, depending, both have the possibility to immediately address the family court. And then the family court decides, with, again, the assistance of all the social workers and all the informations they get from police on everything. So it is multidisciplinary by nature, because the civil judges, the family judges have the automatic assistance of all the institutions they need. The same goes for the penal judges. The penal judges for children are specialized as well. And they also have their social services, the protection services and the probation officers and so on, who are needed for the execution of the decisions of the juvenile justice court. And for nitty-gritty small things, it's a single judge dealing. Nevertheless, even in the smallest issues, concerning the smallest issues, even if diversion is used, social services have their word to say, because they are bringing all the information to, in the case of diversion, to the prosecutor, in the case of a trial, to the judge. If it is a heavier crime that is going to be handled, then we have the judge with two lay officers. And if it is a real bad blood crime, then we have the jury. If we have two lay judges, those lay judges, like in Italy, have to be specialized. They have by profession to deal with children, either as teachers or as social workers or as doctors, whatever. But they have to deal with children. Concerning the jury is not so. The jury is a normal jury, a jury as for everyone else. But the judges that are presiding are giving quite a lot of information to the jury members concerning children. So this is the system in Austria. And I have to say, I am not a judge in Austria any longer, but I have to say, as long as I was there and long after, it worked quite well, because as I said, the multidisciplinarity is something that is inherent in the system. I have never seen a juvenile judge nor a family judge working alone without any information from a lot of people. We also have then the possibility in civil matters as in penal matters to have what we call the person of trust. that is a person that the child can choose if the child has the feeling that the child is afraid or doesn't trust anyone or so, and the usual person the child is choosing is the grandmother. I do not know why it is the case, but it is the case. So this person is not a person in trial, has no rights whatsoever, has just only the rights to stay next to the child, hold hands, and tell a judge, please, judge, the child has to go to toilet, or this kind of things, not more. But is there as an assistance, a real assistance to the children in civil as in penal matters. Not with so for victims and witnesses in penal matters, and for every child in civil matters. That's the system. Thank you very much for giving me the floor.
Yeah, thank you very much. It was very illustrative. Yeah, I think this issue of jurisdiction is a very important topic to be discussed in our association, because before the convention, many countries have had this structure of courts uniting child protection and juvenile justice. And after the convention, there has been a major change in many countries, giving to family courts the jurisdiction on child protection. This was the case in Latin America. Brazil is one of the few examples of keeping also a specialized court for child protection and juvenile justice. But we are discussing it also a lot, and so this is the reform in Italy is very important for us in Brazil, because we see that there are overlapping issues that are being discussed both in family courts and in child protection courts. I see that there is in Article 23 of the Italian reform, there is also a big concern on cooperation with the criminal court, because we have sometimes the same child is victim in a criminal file. They have also a file in a family court in child protection. So how do you deal with these situations without incoherent decisions? So I think this is very important. In Brazil, we have the specificity of having also class actions and collective actions in child protection courts. So this gives another perspective of public law. So we deal with public policies. So, but there is also the same concern that Renate was sharing of bias, especially because families and children who are dealt within the child protection courts are normally more vulnerable. They are migrants, or they are poor, or they are from minorities. And sometimes this gives, there are some criticism on how judges deal with this kind of issue. So a certain concern on how, if we should or not do the same movement as you are doing in Italy and you did in Austria, to unite the jurisdictions of family court and child protection. And we also
if I may
Yes.
interrupt, because you said
Yes.
it is difficult between the penal judges and the family judges. It's not, because as soon as the penal judge sees that the child is in need, he gives a copy of the file to the family judge, and the family judge immediately deals with the protection measures.
Yeah, but in Brazil, the criminal courts may also give some protective measures. So this may give some conflicts, and also the child may be hurt in both courts. So if you're trying to avoid revictimization, should we do, for instance, in cases of parental alienation, if we accept this kind of false allegations of child sexual abuse, should the family court hear the child as much as the criminal court or not? So there are some potential overlapping activities that should be concerned. And I saw that I would like to hear both Daniela and Joseph about this Article 23, where you deal also with cooperation. And we don't have the experience of honorary judges. We have consultants as professional staffs, psychologists and social workers. I think multidisciplinarity is very important for both family and child protection courts. But the way this structure is held is, I think we should do a research, as Joseph was introducing us to evaluate these changes and just check what were the good outcomes and the challenges that all these changes have brought to granting children's rights. So I will give the floor back to Daniela and to Joseph if you would like to make some other comments on what on the inputs we brought from Switzerland, Austria, and Brazil and Latin America. And I would sincerely like to hear you more about this cooperation issues. I would also like to mention that I was very impressed by in your law that one aspect is that the legislator is trying to speed up the procedures, establishing very short deadlines. And this is very common in Brazil as well, and I've seen other legislations, as if these deadlines would be enough or sufficient to really speed up the procedures without changing the structure. So I would like to problematize this kind of aspects as well. And I saw, sorry, for the last aspect is the introduction of electronic communication. I saw that there was a very, there was a lot of articles on that in your legislation. I think after the pandemic, this online hearings and online communication is also a new issue for everyone. How far this is good or not for people, and what is allowed or acceptable in our cases to deal with online aspects. So thank you.
So if I may take the floor, thank you. I begin with the specialization within the court. As in Austria, we have a specialized social service based in the Ministry of Justice, but only for criminal cases. It's very useful, they work a lot, they are very specialized, they have a good preparation in order to liaise with the children and family. Children, I mean, in the penal cases, they are usually from 14 to 18 or more when we are late in dealing with the case. And I think that this is very important because a social service with a regional base can sort of equalize the intervention. They're not spotted different from place to place. We have not a similar support in civil matters. I mean, of course, we do not in civil matters arrive to the instruction, to the decision without having dealt with the social services, but with the ones in the local ones. In many cases, in most cases, they are the ones who send the report to the public prosecutor, the juvenile public prosecutor, in order to initiate the proceeding. So they do not have a bias, but they are the people asking the juvenile court to intervene. So it would be very important to have a staff, a social worker staffs based in the court. So far, till now, it is an experience when and where the specific juvenile court has succeeded to have this help from the local authorities. For example, when I worked back in the years in the juvenile court of Torino, we had some social workers for the adoption activities, and it was very precious to have these ladies liaising with a local service. It was invaluable aid. We do not have in Rome, that is Rome, something like that for normal civil procedures. And it means that the more it happens, and the more it's important to have honorary judges that can interpret, liaise, better explain to us and to people what's going on and what we can forecast for the future. Coming back to what Eduardo said about the digitalization, yes, it's the mandate of this reform is to make it quick with terms and make it quick with the digitalization. 2 words about terms. It's true. The law has set forth many very quick terms, which are mainly, how can I say without appearing let's say punitive, because they're not objective. They're, for example, the social service remove the child from the family house because something is very wrong. According to the first draft, this order should be at once noticed to the public prosecutor, which at once had to open a civil proceeding, in which at once the removal should be confirmed or modified or revoked, with another very short term in order to have the final decision. That's too much. There's no time for thinking. I mean, of course, we have to be fast. We have to decide fast and communicate with parties very fast. But sometimes a accurate, considerate decision needs time. That's what is wrong in making so quick terms. The fundamental thought under this construction made by the reform, local sections and central section is, I've heard with my ears, better to have a decision at once and have it revised in second degree. But this is a loss of time and of resources. This is wearing people. A decision must be quick, but it must be considerate. We cannot rely only on the second degree, on the appeal. That's why I think that all was thought on the point of view of the conflict between adults. It is not really a reform which has in mind the best interests of the child. For example, and this is very meaningful, as I said before, step back. The reform has a batch of norms applying to the current juvenile court, and as a part regarding the new court for minors, children and families. It could be that they do enter into force in different times. it could be that the procedure applying to every court applies also with the juvenile courts still leading. And in the second time, the complete reform of the new courts can come into force. This is a possibility. In the procedure applying to every court in family matters, as I said before, honorary judges cannot hear the child. The hearing of the child must be done by the professional judge. It has been said, not by me, but I agree. The hearing of a child is no more, is not a way to have the child express themselves in the procedure, their needs, their ideas, their feelings. It's an evidence. Parent against parent. That's why we need the law provides for that. The hearing of the child must be done by the professional judge, not by the honorary judge. This is the taste, the flavor of this reform. Regarding to the digitalization, we arrive as juvenile courts are very poor to this new era, because we have a very poor digitalization for the moment being. On the contrary, the ordinary courts have worked since years for the digitalization. They can have no paper file. All we have is on paper. So then the passage of procedures from the juvenile court to the ordinary court will be problematic, dramatic for ordinary court themselves, because they are going to receive lorries of papers in this way. We have seen in the reform, and we have spoken only about the civil procedure reform, but is on the verge of being approved and published also the reform of criminal procedure. And also in this criminal procedure, a great importance is given to the digitalization and visualization through video conference. It is provided for that even witnesses are going to be heard with the video conference. We'll find out if enough means, enough staff is going to be given in order to make this reform viable.
Thank you very much, Daniela. We have a question from the public. In fact, it's not just the public, it's our current president, Dave Stuckey. He was wondering how our association could best assist in these efforts in our various countries and juvenile systems to advance judicial reform, promoting the best interests of children and families. And Renate Winter has suggested to launch a request to judges of our association in different systems to give an overview of their system with their positives and negatives, inputs, and put overviews to discussion. This is something that we may, in fact, organize. We are focusing in our association on researches. We just made one on child participation in family and child protection matters. We were wondering and planning to do one in juvenile justice. We began to draft a questionnaire, and I think this issue of the structure is very important, and maybe it's a previous step to consider all these other topics. I don't know if Joseph would like to make some comments as well. Please, you have the floor.
As the AIMJF president asked, in fact, I have to remind that during the last proposal reform in Italy, there was a big intervention of international organizations. Renate, remember, and also Avril for the AIMJF and other organizations like Council of Europe and so on, because we was in the quite similar situation, but in this case, I think we don't have any possibility to make the change. In any cases later, but the fact that, as Daniela said, this reform was integrated in the next generation EU. This make impossible to try to discuss to make a big change in the proposal reform or try to reflect more, because the next generation EU have a very strict timing on the path. Then this made impossible make any possibility to make modification. Concerning the cooperation between courts, yes, in Italy, cooperation exists, but is not, as Renate said, in Austria, automatically. We have to ask the court or the parties produce during the hearings or the memories, documentation concerning decision in other proceedings of the same parties, then is not automatical. Maybe this can be something to reflect on. And concerning online hearing, I think it was a very good idea during the pandemic to have hearings online. We continue in very few cases because all the law on that regulate very precisely this kind of hearings is not in force anymore. But for example, for hearing, children, unaccompanied for children that are in located not so near the juvenile court, because we know juvenile court, they are not closer to users, as Daniela said. They have a district competence. For example, Genoa is for the Liguria and also 2 provinces of Tuscany. But I know that again, the lawyers was not favorable to the online hearings. And again, lawyers win in this debate on online hearings to try to limitate, first of all, and not leave permanently this possibility. That's all for the moment.
Okay, thank you. Ursina, you made some questions on the chat. Do you want to raise them, or make any other comments?
Yeah, maybe if I was just wondering, I guess Italian colleagues can help me to better understand what are the dynamics behind the reform. Who is it? How much is it EU related now? Also specifically the child-specific questions, or how much are other forces there? If that can be said, this is really curiosity, and also to understand better why comes what, or why were you, the juvenile judges, not heard, for instance, which would seem quite illogical. But maybe the dynamics in this question, they relate to one another. If you would like to respond to that, if you don't want to, we can skip it and I have another one.
It's difficult to say why we were not heard. Some very skilled family judges were heard and participated very deeply to the works of the committees and commissions which edited the drafts. Perhaps it was felt enough. Surely the time, as Joseph said, was very short. The last times when the reform of juvenile courts was discussed in 2003 and 2014, there were drafts of law edited by the government, and we had plenty of time in order to discuss it. There was not the fact surprise. This time, I'm afraid that the fact surprise was not so casual, and that was the goal to make this court, the unique court, whatever it takes. So here we are. It can happen so that experience and real life can prove better, and that the system is working. It depends, I think, very much on how largely the judges of the local sections will use the honorary judge in the sense of juvenile honorary judge, because the text is quite strict, but interpretation can lead to larger solutions. Yes, I think that the experience of how strongly, how robustly the association and a large part of the society worked against the reforms in the previous occasions was a good teaching in order to organize these reforms that is going to pass in the future weeks, the next weeks. That's why it was I'm afraid that it was not a voice they wanted to hear. Very, very frankly speaking. If perhaps Joseph have something to add according to his experience.
Joseph, would you like to add something?
I try to find a comparison among the number of lawyers and the judges in Italy, because this, I think, is an important element to take into consideration, because there is a number of lawyers in, for example, in Rome, that are the same, quite the same of the number of lawyers in all the France. And the gap between lawyers and judges is enormous. I mean in this that the power of lawyers, because Daniela expressed at the beginning the fact that this reform was proposed and pushed by some lawyers association. We have to understand that also this is the same in the parliament, in Italian parliament. I don't want to say 40 lawyers that still practicing his professional activities during the activity of a parliamentarian. were named in the parliament, and one judge who can, in the same time, 14 and 1, who the judge cannot continue to make his activity during the mandate. Sorry, I couldn't find the correct term. During the mandate, the lawyers continue to make his professional activity of a lawyer, and during the parliamentary mandate, the judge cannot do it. And of course, this, I think, is also a sort of conflict of interest for the lawyer. When the lawyer make reforms, for example, if is a lawyer who deal with criminal issues, he can push for change the law in favor of the people who defend. In this, I just would like to understand that it is very complex, the situation, but of course, the power of lawyer in Italy is really, really important. And the EU is intervene later, not at the beginning, because the European Union intervened only to accept the packet of reforms for have, as Daniela said, the justice more efficient and quick. Was not in question how to do the reform and if doing in juvenile justice system, but to include in the reform also this one, and was no possibility to discuss, to have discussion on it.
Thank you, Joseph. I would like to check if Ursina and Renata has any other comments or question. And Ursina, I think you have one.
Maybe a very quick one. It's probably a yes and no question. Does the reform package come along with a kind of implementation plan where someone would, write down, we need that many judges, that equipment, so much money to get these people professionalized, specialized in all the areas, implementation plan accompanying the reform process, or not yet?
No, not yet. I must say that the last draft, what is going to be published on the official Gazette, we have not yet seen. It's going to be revised slightly, but the last touches, but we have not seen. It provides for the text that we know that is probably going to be the final one, provides for the emission of decrees by the Ministry of Justice, whose content we cannot now say. For the time being, we'll see the last version, which will be published. The order was no extra costs, so we don't know. And it's quite peculiar, and it cannot anyhow work, and it was pointed out not only by us, but by us, but the Supreme Council of the Judiciary, and from all thinking people, that the law by now, as we think that will be approved, provides that judges in the local sections, charged to be judges of the family and for the children and persons, will be exclusively dedicated to these matters that can't work perhaps in larger law courts where already there is a section for family matters, but in all little courts where they have 3-4 judges, it cannot take a judge only for doing that, because it's going to be crazy. They cannot work. And I think that when it comes to be a reality, the same precedents of law courts, ordinary law courts, will face the impossibility of practically face this change. By now, I repeat, there is no provision for changes or implementation of judges. Let's see, we cannot say now, but we have abundantly made clear that it was not possible in this situation go on with this reform.
Thank you very much, Daniela. I think we have planned to have a 90 minutes webinar, so I think we are already done with our time. So I would like to thank you, all of you, Daniela Bacchetta in special, for her presentation and all the inputs you brought from the Italian reform, but also and especially the comments and questions raised by Joseph, Ursina, and Renate, who have given a very broad perspective of what is going on in Europe. And I think we came out from this webinar with some inputs on how the association can bring the discussion to a larger public. Renate and our current president, Dave Stuckey, have made some suggestions on what we could do. So I think this is a topic that we will keep discussing and having more broader participation of all our members and a larger public. So thank you very much, and I wish you a good day.
Thank you.
Bye-bye.
Bye-bye.
Thank you. Goodbye to everybody.
Bye,
Goodbye,
everyone.
Renate.
Bye-bye, thank you very
Bye,
much.
Joseph. Bye.
Bye.
Ursina.
Bye, danke vielmals.